This is the regular meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force called to order at 4 p.m. on Tuesday, September 13th. Mr. Rustum, could you call the roll, please?
Yes, Madam Chair. Member Snyder. Snyder absent. Member Nee absent. Member Washburn.
Here.
Washburn present. Member Wolf.
Present.
Wolf present. Member Johnson.
Here.
Johnson present. Madam Chair, we have a quorum.
Thank you. Mr. Rustum, could you call the next item on the agenda,
Madam
please?
Chair, may we have a motion to excuse Member Nee?
Oh, okay. Do I hear a motion?
So moved.
Second.
Is there any public comment on the motion to excuse Member Nee? Seeing none, Mr. Rustum, could you call the roll, please?
On the motion, Member Snyder. Snyder absent. Member Washburn.
Yes.
Washburn, aye. Member Wolf.
Aye.
Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Madam Chair, we have 3 ayes. The motion passes.
Thank you. Chris, could you call the next item on the agenda?
Yes, Madam Chair. Item number 1 is approval of March 8, 2011 regular meeting minutes.
So moved.
Do I have a second?
Second.
I read through the minutes. I have one small edit on page 4 of the packet. Just we need to insert a comma between Johnson and Washburn to make sure we don't have somebody named Johnson Washburn. Is there any public comment on the motion to approve the minutes? Seeing none. Any members? Okay. Anything further? Okay. Mr. Rustum?
Point of order, Madam Chair. Through the Chair, Member Wolf, on the timestamp.
On the
On the timestamp,
timestamp.
I have been told to change it to approximately instead of starts about.
To change it to.
Oh, you mean the words
Yeah,
literally?
no, I understand what he's saying. Let me just see. Approximately instead of starts about?
Yes.
Why? It is what it is. If you say starts about and approximately, it means the same thing.
Okay.
I think you'll have more of a formatting problem using the word approximately.
They wanted to abbreviate it APPROX dot.
That's fine.
Yeah, whatever. Sure.
Okay. Thank you, Madam Chair.
Yeah, I was worried about the formatting too, but if it's abbreviated, okay. Chris, could you call the next item on the agenda?
No, Madam.
Oh, we didn't vote on this. Oh.
No.
All right. Could you call the roll, please?
On the motion, Member Wolf.
Aye.
Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Member Washburn.
Aye.
Washburn, aye. Madam Chair, there are 3 ayes. The motion passes.
Okay. Mr. Rustum, could you call the next item on the agenda?
Item number 2 is approval of July 12, 2011 regular meeting minutes.
So moved.
Second.
Okay. Member Snyder has joined us. I have a couple of small edits. Page 10 of the packet, up near the top, about 7 and 8 lines down, the Ethics Commission should be capitalized. And then the next edit I'm suggesting is same page, item number 6, towards the end of public comment. It reads, Alan Grossman said that the district attorney only handles matters that involve crime. And I suggest that we say, rather than and because of it, put and therefore the task force. So substitute therefore for because of it.
And add saint to. That's a really unfortunate thing to say, but add saint to Mr. St. Croix's name. It just, the ST is missing in that same sentence.
Yeah. Okay. Let's see. Oh, then on page 12, near the top of the page, item number 10, and public comment,
It should be
right. But then I don't know, and don't quite understand what's being said here. Alan Grossman said the task force could send the letters, but it really depends on the quality of the supervisor. So I'm not sure what he meant.
I can rephrase it, Madam Chair.
That may be what he said.
That is what I think that, yeah.
I think so.
It's not easy to get honest political representation.
The quality, okay. All right, if everyone else is happy with the wording.
If not, we'll hear from him.
We'll hear from Alan, okay. Okay, let's just leave it then. All right, that's all that I saw. Anybody else? Any public comment? Seeing none. Mr. Rustin, would you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 4 ayes. The motion passes.
Could you call the next item on the agenda?
Item number 3 is approval of August 9, 2011 regular meeting minutes.
So moved.
Second.
Any comments? Member Johnson.
On page 16 of our packet, item 5, it says Member Johnson reported to the committee on what occurred at the most recent Ethics Commission meeting. If we could just add like a sentence in there that says something like Ethics Commission staff reported it would make recommendations on the regulations to the ethics commissioners, just to have an idea of where it was at that moment, you know.
One thing that I read the minutes and was generally happy with them, in particular that they reflected what members of the public said. What we still don't have, and I don't know that this is something we want to address for these particular minutes, but going forward, do we want to, and this is a case in point, do we want to have the minutes reflect more of what we say? In this particular case, what Member Johnson said about what transpired at the meeting was important to our work. I don't know, members, what?
I think is appropriate.
I mean, in some instances, you know, I'm always going back through these things. In a little while, you hear that I've read every order of determination since 2000. And it's real hard when they don't have some kind of, it doesn't have to be detailed, but something about where it was at, which is kind of why I put that in there, because otherwise I have to go look at some other minutes or go to the Ethics Commission. At least I would know kind of a gauge of where it's at. So what I'm saying more specifically to the task force as opposed to just this Ethics Commission thing is that, you know, it goes from the task force and we send it over to compliance. And then it just says at compliance, they said to send it back. So sometimes if we have a discussion that is associated with there were no documents, or, you know, if there's a disagreement among the compliance and it gets sent, it would be nice to have at least one sentence that sort of described the status at that moment. You know, it doesn't necessarily have to be quite as, you know, as descriptive as the members of the public, because we're right here and we were participating. But in those instances, it would be useful.
No, I think it is important to be able to track yeah, we're asking for reports on the status of the orders of determination. That's our job here. So I think that needs to be captured.
Madam Chair, so for this particular issue, what the Member Johnson is suggesting, what would be the context? How would you like to make a one-word contextual statement to make this clear?
You mean on 6?
Was it on 6 or on 5 that you were talking about?
I gave the administrator one sentence on 6, just
Oh,
stating that
okay.
the staff had reported that it was going to make a recommendation to the commission. Because then,
Okay.
like they went to the meeting yesterday, the Ethics Commission meeting yesterday, there was no mention made of it, which is kind of good and bad for us at the same time.
Right.
But an example would be on I'm sorry. That was item 5. You were
Item
right.
5, yeah.
I said 6. An example would be on item 4, right above that. It says we're, that could you add Ms. Gamez's last name there? Do you see that where it says heard, complainant Alicia? It says she presented a status report and that Dr. Bhatia represented the Department of Public Health. And we had quite a detailed discussion, which I thought especially the conversation that Member Snyder had with Dr. Bhatia, going back and forth about how are the records kept. So there's nothing in there. Maybe if there was a sentence that said, members discussed how the records were kept at Department of Public Health, and search, possible search tactics or reasoning. There was a lot of, so that when you go back to look at it for the task force, you have an idea and you can recall, I particularly recall that because it was, I was very appreciative because I was just getting angry,
Right.
saying, I wanted to say, he said, if they're haphazard, how can I search them? And I wanted to say, you search them, you reap what you sow. If you want to keep them haphazardly, so shall you search them. But I thought it was more reasonable, I don't want to say reasonable, but more, step by step walking it through the way Member Snyder did it. So that would jog our memories for when they returned. Something like that. I mean, it might be something that we could provide. When we review them, it's hard.
Oh, it is hard. No, I think now that we're getting through the backlog of our minutes, so that's one good thing. We're making progress. But I think going forward, I would like to see, like I said, I think Mr. Rustum does a really masterful job. The public may disagree with me in certain circumstances, but I think he does a masterful job in capturing what the public has said, the gist of it, the important points. And I think that I would appreciate him doing something similar for what we say that's directly pertinent to the status, the findings of the status of the order of determination, compliance with the order of determination, and then other of our bright ideas that we want to memorialize. So, other members, do you support this notion?
Yeah.
Member Wolf, Member Snyder?
The question becomes how do we direct Chris to be making the correct context for such a long discussion as that particular one? Because there are so many different aspects of it.
Yeah.
We all know that he's getting it from one side to reduce the amount of stuff in the minutes, and we're wanting more. So if we're missing the key context of the discussion, and we're looking for one sentence. It's a little hard, but how would he go about determining what that one sentence is?
Well, it doesn't, I mean, if it was long, it depends on the nature of the discussion. I mean, in that example, there's really nothing there that says nothing about, it says confer with the complainant to identify and produce the requested documents. I mean, it doesn't say anything about why we made that motion. So if it even explained the motion, if it
Okay.
even,
Okay.
Well, I
Fair
think
and then we could add to it.
That gives him at least something to hang on. He's not trying to pull something out of a hat. At least there's something there that he can base an explanation on that's helpful. What do you think, Chris?
Through the chair, I would suggest that the task force chair talk to the clerk of the board. Because
I would suggest that the task force chair talk to the clerk of the board too. Because the minutes aren't for her.
Right.
It has nothing to do with Chris. It's just that I have to go through these things. I don't have to, but who else is going to do it? I mean, I don't me personally, but whoever's sitting on the task force, who's going to look through them and see what's going on? And so I'm overwhelmed. It's hours and hours of work sometimes because you don't know where anything is at, and you have to I have to go back and try to remember it, and then the more complaints you hear,
It compounds.
the more you wonder, wait a minute, was it that one?
Yeah.
Was it this one? But that's why I was saying if it just explained briefly, it doesn't have to be, like in this, we made a motion because to identify and produce the requested documents. I mean, it doesn't really say that, the complaint, the respondent, hadn't turned over all the documents, or the task force found they hadn't.
I think, there has to be more information about the findings at the hearing. So we have a hearing about the status of compliance, and we need to have just a sentence or two for each side, for the complainant and the respondent, so we know what happened. And that, even that amount of information would help us make sense of the motion that we made. And, referring this back to the full task force, we would know, what happened. We wouldn't have to rack our memories and almost relitigate the case as we sometimes do, because we can't remember what happened. We spend a lot of time doing that simply because we don't recall the status.
There always is the playback.
Well, there is always the playback, but so
It's just that there's, we have like a full-time job, and then the meetings are long, and then you're having to listen to it again as a whole.
Mm-hmm.
Or even where to listen. It would just, I think, would be helpful. But more than that, it's a record that we send out to other departments.
Mm-hmm.
I know they ignore it, but
So you're going to talk to the clerk of the board? So Member Johnson or Chair of the Task Force Johnson is going to talk to the clerk of the board about our need to have more context for our motions, for starters. Yes.
yes.
Member Johnson.
Sorry, yes.
Okay. Public comment on our discussion and the motion?
Ray Hart's Director, San Francisco Open Government. And listening to your discussion, I think there are a couple things that I would recommend. Would be one, if one of the members feels that a certain area of discussion by the task force was the basis for the motion, they could simply tell Mr. Rustum or note, say, please make sure we have some indication in the minutes regarding this matter. The second thing is the issue of the clerk of the board. I know Mr. Rustum probably doesn't believe this, but when I give him a hard time, I always feel guilty about it for the simple fact that I always am concerned that some of the issues that I'm raising with him are not anything that is of his own making. As I did an IDR for Ernie Lorente, who was the DCA prior to Mr. Threet, and found out that he only put in 6 hours a week on task force matters, I was kind of saying, well, gee, by the time he attends meetings, what time is there left? And I always wonder whether Mr. Rustum is caught between the rock and the hard place with the board, the clerk of the board telling him, do this and this and this, all not related to Sunshine, and making it very clear to him without saying so that Sunshine matters are at the bottom of the to-do list. So I really think that that discussion should be related to what her idea is as far as the time that Mr. Rustum is given to perform the tasks which the Sunshine Task Force has for him, because he does work for the city. He's a city employee. He reports directly to Mr. Caldiera, who is a city employee, and ultimately to the clerk of the board, who is a city employee. And while he may perform most of his tasks on your behalf or for you, you do not have any control over his evaluations, promotions, and other things which are the critical factors in his rating his job performance and things like that. So he is kind of caught between the rock and the hard place of trying to do what you ask to be done. But I think you have a clear right as the body for whom he is doing the work to have certain expectations, and that shouldn't be under the control of the clerk of the board. The clerk of the board may be able to somewhat control resources, but at the same time, I don't think they have. I don't think the clerk of the board has any right whatsoever to tell you how to go about your business.
Thank you. Members, anything further? Okay. Mr. Rustin, would you call the roll, please?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, there are 4 ayes. The motion passes.
Mr. Rustin, would you call the next item on the agenda?
Item number 4 is hearing on the status of the August 23rd, 2011 order of determination of Cynthia Carter against the San Francisco Municipal Transportation Agency.
At this time, I don't see either party in this matter. So, did you, Mr. Rustin, did you hear from either of them?
Madam Chair, Kathy Fowlers contacted me yesterday, and she says, why was she contacted regarding this matter? And I said, because the task force had found that the real person who had to be responsive was Ms. Salaya.
Mm-hmm.
So I told her that since it is the task force had found Ms. Salaya in violation, she is the main person or the main character, and she has to appear.
Mm-hmm.
And I did inform Ms. Salaya that the meeting was being held and she needed to appear. Also of note is in an earlier finding, which was, I believe, 11016, Andrew Cisneros against the MTA. And that's when, after I'd sent her the letter to the, I believe it was the Ethics Commission, she had written back to say that she stands by her for what the city attorney has told her, and she still, she says there's nobody else to attend the meetings.
All right. This was Ms. Salaya telling
Yes.
you. Yeah. Okay.
She said the city attorney told her she didn't have to attend the meetings.
Not that she says she stands by her whatever she's been told by the city attorney.
Hope she can do it in Superior Court. I'm ready.
Okay. So, since the complainant isn't here, do we simply, do we continue this matter? Do we refer it back to the task force? Or
We didn't
Well-
hear from the complainant.
You
the
hear from the
complainant's?
complainant.
Oh,
I mean, the question become, we don't have any information as to whether the order has been carried out or not, so
Continue to
know,
the next.
we can. Or you can just,
Table
maybe
it?
they just dropped it. The complainant just, I mean, I guess it's our order, so it has really nothing to do with the complainant anymore, except whether they receive the information.
mm-hmm.
But, yeah, continue it, and then after that, if not, drop it,
Okay.
I guess. So,
So we need a motion to continue
move to
this.
continue.
Second?
Is there any public comment on the motion? Okay. Mr. Russell, would you call the roll, please?
On the motion, Member Snyder.
Aye.
Snyder, I Member Wolf.
Aye.
Wolf, I Member Johnson.
Aye.
Johnson, I Member Washburn.
Aye.
Washburn, I Madam Chair, we have 4 ayes. The motion passes.
Okay. Could you call the next item on the agenda?
Item number 5 is hearing on the status of the August 23rd, 2011 order of determination of Ray Hartz versus Luis Herrera of the Public Library.
All right. I see the complainant. Mr. Hartz, you have 5 minutes.
Thank you. I'm not going to go ahead and re-argue the complaint. I will say that at the last Library Commission meeting, there was an agendized item regarding the placement of 150-word statements. There was a brief recap by Ms. Blackman, which was truncated, really not discussing the actual order of determination. During public comment, I had received a copy of the draft of the order of determination that had been completed by Mr. Threet, and I read the findings of facts and conclusions of law to the Library Commission. They then proceeded to have what I consider to be no discussion whatsoever. The only thing they did was ask the city attorney, the deputy city attorney who was present, whether or not the memo that the city attorney gave them is something they stand by, and she said yes, and they didn't see any legal problem with it, and therefore they just decided not to take any action at all. So basically what I'm seeing is they're just basically saying we don't care. They didn't have any discussion. The Library Commission itself did not have any discussion whatsoever about your order of determination. They simply got an okay from the deputy city attorney to continue doing what they are already doing. I'd like to address a couple of points because I have a funny feeling I know some of what might have been in the response that you referred to earlier. And Mr. Herrera is a city employee. He is employed by the city, and he is also the person in the public library who would be responsible for signing a sunshine declaration each year and for enforcement of that in the public library system. Ms. Blackman is a city employee also. She works directly for Mr. Herrera, who is her supervisor. And although both of them may work with and or do work for the Library Commission, neither of them works for the Library Commission. And what I'm saying is by that Mr. Herrera has a responsibility to carry out his duties in accordance with applicable law, including the Sunshine Ordinance and in this case, this order of determination. The simple fact that the Library Commission chooses to be obstinate and tells, Ms. Blackman to do something doesn't give her a free pass to just go ahead and do it. And there was no attempt by Mr. Herrera to ask the deputy city attorney where he stood as far as I'm a city employee, I've signed the Sunshine Declaration, where do I stand in ignoring the determination? So basically, I'm not too surprised. So I would like you to send this back to the full task force, the recommendation to, I don't see there's going to be anything that's going to happen that's going to change their position. They've been pretty adamant for the last year about this. I would like you to send it back to the full task force with a recommendation of sending it both to the Ethics Commission and the district attorney. And that is based on a number of articles I've read recently regarding district attorneys going after bodies that were not obeying the Sunshine or the government laws. I would like you also to consider making a recommendation to the full task force for finding a violation of the Brown Act, in particular 54954.3, public's right to testify at meetings, subsection C, which reads, the legislative body of a local agency shall not prohibit public criticism of the policies, procedures, programs, or services of the agency or of any of the acts or omissions of the legislative body. Nothing in this subdivision shall confer any privilege or protection for expression beyond that otherwise provided by law. In this particular case, it is provided by law. The Sunshine Ordinance says that if I wish to have, or any member of the public wishes to have, a 150-word summary put into the minutes, that they can be put into the minutes, that they should be. And this task force has ruled in that case. The Attorney General wrote the following. The body may discuss an item that is not, I turned it to the front. When a member of the public testifies before a legislative body, the body may not prohibit the individual from criticizing the policies, procedures, programs, or services of the agency or the acts or omissions of the legislative body. Public meetings of governmental bodies have been found to be limited public fora. As such, members of the public have broad constitutional rights to comment on any subject relating to the business of the governmental body. Any attempt to restrict the content of such speech must be narrowly tailored to effectuate a compelling state interest. Throughout the entire process of both hearings, this and 10054, not at one time has anyone from the Library Commission or Ms. Blackman given any substantive reason why putting it in would be harmful. In fact, at the last meeting, Mr. Munson was very clear in that his reason for not wanting them in were based on the content, which is directly prohibited by the Brown Act. And so I think that that is very clear in that their intention is really to restrict the comment. And I'd say there really isn't any difference between oral public comment and written public comment, especially if they are one and the same.
Thank you. Is there anyone here to offer evidence in support of the complainant? Facts or evidence in support of the complainant? Okay, seeing none. The respondent is not present. So the matter is with the task force. Member Wolf.
I think I was waiting for Mr. Hartz to close his statement with whether he felt that public verbal versus and or written comment would be considered one and the same. And I think that's an important factor for the task force to state as a matter of fact so that it's clear when anybody shows up with a similar kind of case, or if there's any question, like through the EOT committee, that it becomes it's a matter of fact, and there's no two ways around it. Public comment and written comment provided for a public meeting. I'm sorry, verbal comment and written comment provided for a public meeting to be contained in the minutes is one and the same.
Okay, thank you. Member Johnson.
The Ethics Commission response to Mr. Hart's complaint 10054 addresses that, and they say the opposite. Just so you, I agree with you, but I just want to let everybody know that what you're saying is absolutely important.
Madam Chair,
Member Wolf.
I would just state that it's not the job of the Ethics Commission to re-adjudicate or to make those determinations. We've already made the determination. They just need to carry out the enforcement. So I would write them a letter back saying, we don't accept while you're free to make your own interpretations, we have already made our determination, and that is what stands. You are to carry out the enforcement, under the Sunshine Ordinance without question. Determine what the enforcement and the consequence and or penalty shall be. Thank you very much. Sincerely, yours truly.
Well, they're going to get this new case 11054 with precisely the same results, and so they're going to get kind of a double dose of our wisdom
Okay.
and admonition to do the right thing. Okay, any other comments from the members? Okay, Mr. Hartz, would you like to? You have 3 minutes to give some final words.
Thank you. I was in the military for 12 years, and after that I spent another 14 years teaching for the University of Hawaii and working with state, federal, and local government in Honolulu, as well as the Office of Hawaiian Affairs and a lot of other government entities. And I'll be honest with you, it kind of spoiled me because one of the things I learned dealing with them was if you went in and looked at the law and actually went to somebody and said, look right here, this is what the law says, they would look at it and they would have a hurried conversation, and usually they would say, well, that's not what the law says, I guess that's what we need to do. Unfortunately, what I'm finding here in San Francisco, especially with the Library Commission, is that their attitude is, we don't really care what the law says, we don't really care who says that about the law or whatever you have to say, we're going to do what we want to do and everybody else be damned. It is unconscionable, I think, that any citizen of this city should have to go before a public body and, number one, argue with them about their right to speak, or number two, argue with them about their right to obtain public records. I think it's in this city, which supposedly has a very liberal reputation around the rest of the country, people would be very surprised to see the treatment that many citizens get. And I think the 150-word statement is an added protection covering something that the Brown Act doesn't specifically mention, but I think its intention is clear, is that I have the right, and any citizen has the right, to make sure that in a government publication, our words are represented in a fair way. And it gives you the added option of saying, if I do not like the way I am being summarized, then I can make a 150-word statement, put it in there, so that what I say, including the tenor and the tone and everything else to go along with it, gets in there in the right place, and it's in place. And really what they've done here is they've taken it out of context so that people have, members of the public reading it have a hard time discerning exactly what applies to what. And then they put it at the end with a long 3-line disclaimer, which basically I think comes across as a kind of an indication that, this is a bunch of nut stuff coming, so don't pay any attention to it. And they do that with the sole intention of abridging free speech. They want instead to have in the body of the minutes their interpretation of what members of the public say. And if you read my statements in any of these minutes that are involved in this case and read Ms. Blackman's summary of them, you will see there are distinct differences, and that is the whole context of the free speech issue. Does the government have the right to take my speech and then reconstruct it, put it in the minutes in representation of what I said? I say no. What they have is the right to put in an innocuous phrase such as, the following 150-word summary was submitted by the name of the person, and leave it stand on its own. If they want to put an additional summary of what they feel it means, I would not restrict them from doing it, and I would ask that they not be allowed to restrict me from having my words in there either.
Thank you. Okay, the matter's back with the task force. For a motion.
Do we have a copy of the minutes? We don't have a copy of any subsequent, well, we have a copy of I'm sorry. Did we get a copy of the minutes for this particular case with regard?
We did.
We did.
Mm-hmm.
Is that, okay.
I think it's appropriate here just to we can refer. I think what we typically do is refer it back to the task force with a recommendation to, right? We go to the task force recommendation to refer it to the Ethics Commission, and I would say for a willful violation due to their failure to show up here, and it's obvious that they have not attempted to comply with the order. So I think, so I would move that we refer this matter to the full task force with a recommendation that it be referred to the Ethics Commission, And I'd be open to a friendly amendment saying that the DA as well, open to discussion for a willful failure to comply with the order of determination.
Okay.
I'll second that.
All right. With the friendly amendment?
Yeah, that's fine.
DA as well.
Yeah, you don't have to make a friendly amendment onto yourself. Just
Yeah, well, what I meant
think
was
it's part of it.
I'll say the DA as well, if everyone thinks that's a good idea.
Yeah,
Fine.
thanks.
Yeah.
I have a comment.
Yes.
One of the reasons why I was asking for the minutes, or any newer minutes from this particular case, if I think Mr. Hartz had testified that they had continually not been doing this. If I'm incorrect, then correct me. But I think it'd be important to include a copy of the minutes showing, what he submitted, just examples. I mean, it really then makes it very clear as to what it is. We don't have to. It's not necessary. We got nothing to explain to the Ethics Commission. They should just carry out the enforcement. So I don't know if it's worthwhile to make it part of the record. I guess it's pretty much part of the record, the original record, versus our record in this committee. So I don't know. I'm just maybe freely associating, but I'm just thinking of, is there any way to kind of really make this a more solid of a case than it already is?
Well, the copies of the minutes that were provided in the packet for the full task force meeting, I think there were maybe several different minutes there, and they were remarkable in two sets. They were remarkable in a couple of respects. One respect was that they're very detailed, and Ms. Blackman, she summarizes what everybody says, so they're very lengthy. But then she summarizes the verbal comments, and then there's a note that the 150-word summaries are in the back, and then they're all listed in the back. So you have to flip back to see them. But yeah, it's clear that they violate the ordinance. So any public comment or any further member comment? Member Johnson.
I'm not sure what to do. I may have a friendly amendment, but again, going back to, we just got the Ethics Commission response to Mr. Hart's complaint 10054, and this is also mentioned in there, where they say that attaching them to the minutes, they is having them in the minutes. So I'm wondering if we should refer it to the Attorney General. Add the Attorney General. I feel like we need outside assistance. I mean, I don't know that Attorney General Kamala Harris is necessarily outside, but the Ethics Commission is, I feel like we're, banging our head on the wall. We definitely have to send it, and we definitely have to be consistent with what we say, but I'd like to draw attention to it. I'd also like to send a copy to Senator Yee. And Governor Brown.
Maker of the motion, are you?
I mean,
happy?
I'm fine with that. I don't see a problem in sending it to all those entities.
Yeah, the DCA 3 sent a email. Leland Yee, who I'm not, it happens to be on his website for mayor, but I'm not pointing it out for that reason, but it's a very detailed description of open government and how technology is coming into play.
Actually, it wasn't.
It wasn't?
It was Phil Ting. Reset San Francisco.
That's Phil Ting?
Mm-hmm.
Oh. Well, it
Yeah.
wasn't, maybe it was the thing from Member Nee about Leland Yee's.
Senator Yee has been focusing on open government issues, at the state level on the coattails of the, not coattails, but his actual investigation of the Sarah Palin presentation at CSU Stanislaus, and has been making, trying to make legislation ever since to try and increase.
Okay.
So
maybe
increase
that's
disclosure at the level. So
I just feel like somebody needs to look at the Ethics Commission besides us. The Ethics Commission needs to be aware that someone's looking at them just to
Civil
start
grant,
building.
DCA 3 suggested that when we make reports to the Board of Supervisors, that we, follow some of the patterns of the civil grand jury or the controller's audits. But this might be it might be better thinking about the civil grand jury, since they already did a pretty extensive report on the Ethics Commission, and they've done one, I believe, on the library. I think they did it on the Library Commission some years ago. I don't remember. I'm not sure if it was that one, but it might be worthwhile to just send it to them too. Maybe they'll pick up city commissions again and look through a bunch of them. Who knows?
So maybe the friendly amendment would be just adding the civil grand jury.
Add the civil grand jury.
Okay, so who are we recommending to the task force this matter be referred to? I'm getting lost with.
So it would be the Ethics Commission, the DA, and the civil grand jury.
Civil grand jury? Okay, so nobody at the state level?
Maybe the Attorney General, since we can do that anyway.
The Attorney General.
Well,
Well, since the complainant cited the relevant part of the Brown Act, which is critical here to support this.
well, it's a recommendation, so the task
Yeah,
force
that's
can
right.
pick and choose.
Right. Member Wolf.
Yeah, I would just be cautious as to making a recommendation to if you send it out to all three. My experience has been, when you go for the AG's office, they're going to look for the local process first. They're going to look as close to local process as possible, and without even looking at the merits or the details of the case. They're just going to say, well, they have a local ethics commission that's supposed to be handling that stuff. Send them a form letter stating to, follow the local process. It's until
I would
that's
like that.
Yeah.
I mean,
Okay.
that's not what I want them to do, but if they did send a form letter, that would be great.
Oh, they do. It's happened before. My other concern is just that if you have too many of them on, it's not directed. That they'll say, well, if the DA's got it on their desk, then I don't need to look at it on my desk. So I would just be a little cautious to be more direct as to making it to a specific office, so that they would have to pay attention to it. If they only saw themselves as being the ones in receipt of this, or being enforcement being directed to, then they're more inclined to respond in a more positive way, rather than through a form letter. So that's my only. I'm just thinking about what's going to be most effective.
Well, why not let's not send a form letter then. Let's be very poignant in what we're wanting them to do. Express our
No, he means-
frustration with
It's not our form letter. It's their form letter. It would be their
No.
form letter to send to us.
Oh, okay.
I don't think what we're sending to them is form letter at all. I think they're getting the detail. But if you only sent it to the DA, if you sent it to the Ethics Commission, you sent it to the DA, then the DA is going to look at that. If you also sent it to the AG's office, then they may say, well, it looks like they're trying to appeal to a higher authority. The AG is going to turn around and say, well, they have a local process. We'll let the local process work its way out. And if they contact us again, then maybe we'll look at it. But, that's all I'm just trying to...
What kind of response has the district attorney ever sent to the ethic? We didn't get one back on the Patrick Manette Shaw through the clerk. I mean, through the chair to the clerk, did we, in that recent Patrick Manette Shaw case with against the Ethics Commission, did we get anything back from the DA?
Through the chair, no, Member Johnson, nothing. We have never had anything back from the DA's office ever. And the
Right.
form letter that the AG's office sends us is, this is a local matter and it has to be handled locally.
Right.
That's the form letter that comes.
Right. So that's what I'm saying is if you only work with an office and you have the back and forth with one office and then the AG, if you do with the AG and they say, well, it's a local matter, then you can return a letter back to them and say, well, actually, the law states that that you are also capable of handling the enforcement, for these kinds of matters. So, especially if it's concerning state law, like if we cite the Brown Act or CIPRA, then it's really more in their court or the DA's court. DA is an agent of the State Attorney General's office. They actually are not a San Francisco office per se. They actually handle state matters. So,
Okay, let's go ahead and vote on the motion, and
okay.
we can talk more about it at the full task force meeting.
So we would have the Ethics Commission, the DA, the civil grand jury.
That's it.
Okay. And that's,
Okay. Public comment on the motion before us. Okay. Seeing none, Mr. Rustin, would you call the roll, please?
Yes, Madam Chair. On the motion, Member Snyder?
Aye.
Snyder, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, we have 4 ayes. The motion passes.
I see now that the complainant for the fourth item on the agenda has come in, but I'm wondering whether we want to continue just to keep this our thread of thought going and hear Mr. Hart's next complaint, which is very similar, and then hear. Oh, okay. Well, if it's all right, I'd like to hear item number 4. Then
We have to rescind our vote to continue, don't we?
Yes.
Okay. So. Right. That's what we were going to do. Is that fine with you? Okay. All right. Okay.
So
We don't have to rescind our vote.
We're
Right.
done. Right. We're going to continue it to next time. All
Right.
right.
Would you like to call for public comment on items not on the agenda?
Oh, right.
Not
Yes.
quite 5 o'clock.
Well, not quite 5. We can hear. Let's go ahead and hear item number
Number
6.
6. Item number 6 is the reconsideration of the January 25th, 2011 order of determination of Ray Hartz versus the Library Commission.
Okay, so this is not the same as we're not reconsidering the whole thing. So, Chris, could I ask you a question? I had requested that you send notice to both parties saying that they didn't have to appear, but that we were going to hear this, right?
That is correct, through the chair.
Okay.
So,
Did you explain your reasoning? For
yeah, this is
adding
my
to
this
the
is
agenda?
my item, not necessarily. You will get a chance to speak, but I'm going to explain it. I don't know if you guys, Chris sent you the additional documents besides the order that's in there. I don't know if we have them or not, but let's start with the reason why I put this on here is because there is on the second page of the order of determination, under findings of fact and conclusions of law, it says, in the second sentence, it says, it, referring to the task force, also noted that the task force had found in a previous ruling that placing the 150-word statement as an addendum was acceptable if it was mentioned in the body of the minutes. We did not, looking for me. Mr. Hartz had complained about that statement on February 17th, which was 10 days after the release of the order. He complained that it was that we were kind of saying the opposite of what the task force had discussed. And later on, the Library Commission, Sue Blackman of the Library Commission, made reference to that, so that to that sentence. And after the order of determination was signed and released, subsequently, there was some discussion among the task force about whether or not that had actually occurred. But at the hearing during which the order of determination was adopted, or that the motion was adopted, the only discussion I transcribed it because it was January 25th of our regular meeting, and Chair Nee says, and I have the approximate times down in the email that Chris sent out to you.
Excuse me, was this for a specific case?
It's for the order of determination that's attached to that I'm reading
No,
from.
I know, but the reference for the previous ruling, was that for a
Well, let me
specific-
just tell you
Okay.
why that I'm bringing this. That's a good, very good question. Chair Nee says, literally, I transcribed it. I have a couple of things. First of all, regarding 6716, the task force has, I think this has come before us before in terms of where in the minutes the summary of a public comment should be. And I think the task force, as I recollect, and I may be incorrect in this, it seems to me that the task force found it acceptable if the actual comment or the 150-word summary of the comment submitted by a member of the public was appended. And that's the only thing that was ever said. And yet here in our order of determination, it says that we noted as a task force that a ruling had been made that you could attach it to the minutes. So, there was no other discussion. There's no further discussion on that January 25th hearing other than him saying, I think I recall that, but I might be wrong. Mm-hmm. And now having that in there is a huge problem, I think, that is going to come up again and again. And there are a number of things that come up like this in these orders of determination. And I wanted the task force, the full task force. So I asked DCA 3 about it as the chair of the task force. And DCA 3 said that a complainant or a respondent, based on our public complaint procedure that the Sunshine Ordinance Task Force has posted on the website, that the reconsideration of task force findings, Section E says within 10 days of the issuance of the order of determination, either the complainant or respondent may petition the Sunshine Ordinance Task Force for reconsideration only if information exists that was not available at the time of the hearing. So DCA 3 felt like Mr. Hartz, as the complainant, had an opportunity to complain if he wanted to. And that's why I included his email, because in fact he does complain about it. And it's not really a reconsideration, and it is, the order of determination was issued on February 7th. Mr. Hartz's email is dated February 17th. That's 10 days. So even though I don't think it's a complete reconsideration, because it would not change the outcome of our findings, but the fact that the Library Commission pointed to it and that it makes us look wishy-washy. In addition, I've gone through every single order of determination from 2000 on, and I found nothing. I'm in the process of reviewing the minutes to try to find out if anything had ever been dismissed. So far, I've found nothing. Dismissed because someone brought a complaint. What I did find was that in October of 2006, which I included a little packet that wasn't included in our packet, but Chris emailed to us. In 2006, the Compliance and Amendments Committee had a hearing. And in that hearing, they discuss Section 6716, and a member of the public who regularly comments, Chemo Crossman, suggested that it should not appear as a separate document, attachment, or appendix, that they should be integrated into the minutes, and that's in October of 2006. I also included the city attorney's good government guide, because in the 2006-2007 edition, which is the reason I included this is because the Library Commission has continued to say that the good government guide says that you can append them to the minutes, these 150-word summaries. But in 2006, the good government guide simply stated, any person speaking during a public comment period may supply a brief written summary of their comments. The summary must be included in the minutes if it is limited to no more than 150 words. That's all that it said. But once the task force took it up as an issue, in the 2007 edition, they changed that. No explanation, but they change it to read, any person speaking during a public comment period may supply a brief written summary of the comments that the person made to the policy body. This summary must be included in the minutes if it is 150 words or fewer. Because this summary is not part of the official minutes adopted by the body, the summary may be included as an attachment to the minutes. So suddenly, once the task force took it up as an issue, the city attorney's office decided that not only could they be attached, but they're not an official part of the minutes, though there's no explanation. And obviously, the implication in the Sunshine Ordinance to a normal, regular person reading them would be that it's part of the minutes. They're included in the minutes. To suddenly parse that out, I think, is misleading. It's misleading to the public. They think they're going to submit this summary, and there's nothing in the Sunshine Ordinance that says it's not part of the official minutes. So what I want to do, because I brought it here to the Compliance and Amendments Committee, I requested that it get put on here because I wanted to have a brief discussion about it, because the task force, we always get behind. So what I'm hoping is that we can just revise the order of determination to remove that sentence, because there is no discussion. And in fact, if you listen to later hearings, the only discussion was Member Wolf saying, I don't remember this ever happening. He basically asked the same thing he just asked, which is great because it's consistent. What case? I've found nothing. I've spent hours kind of looking through I've read every order of determination, and prior to 2006, they used to give an order of determination for everything. If they found no violation, if the task force took no action, there was an order of a determination for it. It wasn't until recently that we switched. I don't know, I wasn't here, but there must have been some reason why they switched, and they only did orders of determination for when they found violations. So I know that it's kind of not something we normally do, although there are, in 2003 or 2004, I don't have my notes in front of me, they do have some revised orders of determination that have been issued. And I think it's a huge disservice to the tremendous amount of hours that we put in, that the public puts in, to leave that in there based on this one statement that might be wrong. Anyway, that's why I have it here.
What does the Good Government's Guide say now, the current edition,
I don't
this matter?
I don't have it, but it's very similar to what it says in 2007. It basically says exactly the same thing, that they're not part of the official minutes and that they can be included as an attachment to the minutes.
Member Wolf.
So I would agree with you, because actually the statement that's in the order is kind of non sequitur to the task force having found anything. Task force didn't find that there was a previous ruling.
No.
It was just a statement by a member that there may have been something, and a response from me is questioning of where that might be, of which there still has been no response. So I think that it's the sentence that is underlined on the last page of the order should be stricken from the order completely. And I would defer to the second signer to
I think the task force has to vote
concur.
on it, right?
Yes,
To-
it would
okay.
have to be referred back, and then it would have to be put on the agenda to, now, whether, we're not really, the question is whether you're not really reconsidering it.
Right.
Okay, as a matter of parliamentary procedure, you're not reconsidering it. What you're asking for is a change. It's like making a change in the minutes. You can find minutes 3 years ago and say, there was some statement in there wasn't true, and then you can make the correction there. If it's significant, then and it would change the outcome of the item, then you'd have to reconsider it. But if it doesn't change the outcome and it's not significant, then I don't see any problem at all. This is kind of think of another word other than non sequitur. There's no basis.
It's not a finding of fact or a conclusion of law.
Right, and
So-
the task force hadn't taken any action to find anything. So,
Member Snyder.
So first, Chair Johnson, thanks for all the work you did on this. It sounds like it was fairly time consuming, so we appreciate it. And I think there is a problem here. My only question is, I don't think it matters as much whether there actually was a previous ruling as whether or not the task force made this observation as a finding of fact or conclusion of law. So what would have been really helpful, so I compliment you for doing all this work, and then I'm going to say there wasn't enough. What would have been really helpful, and will be really helpful for the task force in deciding this ultimately, is to have the minutes of this meeting, the minutes of the meeting that this order of
It says
determination.
nothing.
So and this is my question.
But I mean, the
Is
minutes.
there-
This goes back to the reason why I did this. The reason why I transcribed the only section where it's discussed. That's literally it. It wasn't even Member Wolf's question about whether or not
Wait, where did you? What are you
I
talking about?
transcribed Chair Nee's exact words at the January 25th.
Where? That's in
It's-
our.
not in compliance
Chris
amendments. At the
forgot to
full
put it in
task
the
force.
packet, but
Yeah,
he
that's what I'm talking
emailed you. He emailed you the documents that I prepared.
Yeah, no,
for
I
him.
have those documents, but where I don't see the transcription you're
There's
talking
a.
about.
It's on.
Oh, is it in the oh wait, filing?
It's.
Oh, I see. Hold
I don't
on.
know how to explain where.
It's in.
I see, at approximately 31 minutes and 45 seconds. Okay, so this is the. Oh,
And
well, this is
Chair-
what I'm talking about. I'm sorry, I didn't recognize what this was.
And member, just so you know, Vice
see.
Chair Wolf, his question about whether or not complainant Mr. Hart's.
Yeah, there's no problem. Then, look,
Complainant
I
men-
think we phrase this as a correction, and we justify the correction based on the fact that this wasn't really a finding of fact or conclusion of law that was integral or a necessary precursor to the decision in the order of determination. It's a little bit, it'll read weirdly now because it's going to say we just say Mr. Hart's is persuasive. Well, that's that's not as complete as our findings of fact usually are, although it may be true. I'm sure it was. But it nonetheless is better than it would be if it included the second sentence. So I think we just phrase this as a correction. And we say, after reviewing the record and going back, the task force concludes that this sentence is not true. The task force didn't make this as a finding of fact. And, I should have caught this on my review of it the first time around. I'll say that right now. I didn't, because it's self-contradictory. I mean, it contradicts what the ultimate order of determination is, and therefore ambiguous, and that's the kind of thing we should try to avoid in orders of determination. And I think we can phrase it as a correction because it's not critical to the conclusion of the order of determination. It's not critical to the order of determination. It's just a mistake.
Yeah, I would go as far to say it was erroneous, because that was the word I was looking for, not so much non sequitur, but it is erroneous because even the context of the statement isn't true. So I think.
But even if it were true, it's not.
It's still.
It's not a finding of fact and a conclusion of law.
That's correct.
Yeah.
But the issue that Member Johnson is bringing up on this, sorry, leave it there, that Member Johnson is bringing up is that now we have city employees and or other bodies, policy bodies that are hanging their decisions to take action on it, which that to me is problematic. So I think beyond making this correction, that we issue a system-wide communique to all commissions, boards, task forces, so on and so forth, stating what we know to be true and what we have found to be true. And that based upon the research that you have done, I would state that. And I would also state that, there is no, despite the good government guide stating that, making the statement that it could be or it should be or whatever it is, should be made as an attachment, that the Sunshine Ordinance Task Force does not see that as being compliant with the Sunshine Law, and that if a complaint comes to the task force with for attachments of public written statements or written statements by the public, that this you'll be guaranteed that this will be the outcome, something to that effect. I think it's important for us to kind of make the statement. Now, if the city attorney wants to turn around and refute that, then let them refute that, because then that makes for good legal proceedings. Because, it's well known that if, despite any existing law, if a city attorney makes an opinion, it basically is held as law until law is created to overturn it or agree with it. So I would state that we, hang a shingle out there and say this is how we're going to rule on this particular action taken by anybody for any public meeting from this point forward, despite what the Good Government Guide says, because the Good Government Guide is not the Sunshine Ordinance. And that's what we do. We make those determinations.
And then
Member Johnson.
I wasn't exactly sure how to handle having the complainant respondent make their
No, I wouldn't do that.
could
I
do
would
it as
just
public comment.
This is public comment,
Okay.
and even if the complainant the case is closed. So now the Ray Hartz, who is the complainant, is now a member of the public.
Okay.
He wants to make a comment. I
But
think
don't we
that's
need a
appropriate.
motion to refer it back to the task, or refer it to the task force?
It's referring to the task force.
Yeah.
Yes.
Yeah, we need a motion.
Right.
Yeah.
Are you making a motion?
Why don't you make the motion since you did all
So
that
we'll-
work? Put your name on it.
We'll make a motion to refer this as a correction. Is that what you're okay? So refer it as a correction to the order of determination for 10054.
Do I have a second?
I'll
With what you said, I wanted to add to it with a letter or a notice, an announcement, maybe
System-wide communique.
a system-wide announcement that this is changed and it was erroneous.
Do you want to say how we're recommended to correct it? In other words, by striking the second sentence in the findings of fact and conclusions of law?
Yes, so a motion to refer it back to the full task force with a recommendation to correct the order of determination for complaint number 10054 by striking the second sentence in the section of findings of fact and conclusion of law, and to prepare to prepare a public notice, a citywide notice that it's incorrect. Is it?
Madam Chair, could we just issue a renewed order of determination or a revised order of determination?
I don't know what the procedure is.
Member Wolf?
On parliamentary procedure, if it's a correction that shows some erroneous context that wasn't part of the record, okay, then either it needs to be corrected to reflect what is part of the record. This is the finding of facts and conclusions of law is not a record of the minutes. It's a form that's used to provide third parties with information. So, it's not, the order of determination is what really matters in this form is what's in the very last paragraph, and that is really what the motion is. Everything prior to that is just support material. So, there's no, I don't even think there's any reason for the task force to even have to take an action on it, though I can predict that DCA 3 will suggest that we do so, just so it's on the record.
I think it's a good idea. Well, sorry, finish.
Yeah, so I think the recommendation would be that while it is not necessary to make this correction official, we want to make it clear that we're by voting that this was an erroneous statement. It shouldn't have been included. It's not part of any information that we provide for a order of determination, but it's just pure support material that is not really part of the overall record. The system-wide note announcement should make clear three things. One is that the Good Government Guide is not the Sunshine Ordinance, that the Sunshine Task Force does not find that attachments, and has never found that attachments have been compliant with the Sunshine Ordinance, and that in the future, the Sunshine Ordinance will rule against attachments of written public statements that are not contained, that are supposed to be contained in line.
Member Snyder.
Just quickly, I think sending it to the full task force is good and necessary, because the danger is that this committee decides that it wants to go back and rewrite orders of determination, and that's a problem because the order of determination is the final document which tells everybody what the task force has decided, the conclusions of law that it has made. It's like a judicial opinion in a way, and you don't want anyone to just be able to go in there and say, I disagree now. I mean, that has a problem because you want continuity of law and you want continuity of interpretation of law. The reason that I think this is just a correction and I don't think it's a big deal is because we're not changing anything about what the task force concluded. All we're saying is that the findings of fact and conclusions of law, in this instance, the way this is written, is a misnomer. What that section is supposed to do is say the task force concludes these facts are true, and based on those facts, we conclude this violation occurred, and then the decision in order of determination says in more detail what that violation is. And this isn't really a findings of fact and conclusion of law. And the fact that the task force had found in a previous ruling, well, that may have been, it could have been a sentence in the hearing on the complaint, which is more just a description of what happened, but it's certainly not a finding of fact. And after having reviewed the transcript that Chair Johnson prepared, it's apparent that that wasn't a finding of fact or a conclusion of law. Therefore, it was, erroneously included. I don't think there's a problem with that because there's nothing being changed about what the task force isn't going back and changing. No one's proposing that the task force go back and change what it concluded as a matter of law. So,
All right. So the motion, Mr. Rustam, could you read the motion? I want to hear from the public.
We could make it shorter. I mean, it will be a revision. And the reason I went back, just so you're all aware, is the reason I went through all that exercise for trying to figure out if there really was such a ruling is when we brought it to the attention of DCA 3, he seemed concerned that we would be changing it, although my reasoning was basically what you're saying.
Okay. So, all right. So, Mr. Rustam, could you read back the motion?
The motion, I do not have it down here, but as I'll go back to the recording and transcribe it.
Okay, so the motion would be to refer to the full task force with a recommendation to correct the order of determination for 01154 by striking the second sentence in the findings of fact section,
Which was included
which
erroneously.
is, you could say, the erroneous statement,
Okay.
and sending a notice to the city departments.
All right. Is there any public comment?
Is there a second?
Or is there,
Second.
there was a second, I think.
There
I
was?
heard, yeah.
Oh.
I'll second it.
Okay.
There wasn't.
There wasn't?
No, we were
Okay.
still trying to figure out the motion.
Okay, all right. I'm trying to move us along here. Okay, Mr. Hartz.
My thanks to Chair Johnson for all the work she's done on this also. Just to make it clear, at the actual hearing in January, the motion had been made, it had been voted on, and after that was done was when Mr. Nee made his comments. And I was sitting at the audience in the time, and I was kind of going like, well, wait a minute. That just kind of negates the whole thing. I would like it to go back to the full task force for a couple of reasons. One is, I hate to say this, but I would like to at least consider whether or not during the actual discussion, the in the minutes issue was discussed, because I believe it was. And in other words, in the minutes means in the body of the minutes. So if that was part of the discussion, I don't think it would be changing the determination or the findings to make that clear in the order of determination, in addition to removing this statement. But as you've seen, that statement has already caused a problem with the Ethics Commission, and I knew when it happened it was because I had sent an email to Alan Grossman and asked him, and he says, "Yeah, it's gonna be a problem." The second thing is that once the full task force considers it, if they do decide to reissue the order of determination, I would like to then request that they forward it on to the Ethics Commission so they can perhaps consider reopening the case that was sent to them initially regarding this matter, because I knew at the time it was sent that would be something that they would immediately hone in and just, like, can't think of the right word, target. The issue really comes down to the simple fact that the city attorney has been very, very careful not to have or allow any questions relating to his opinion. If you look in the Good Government Guide, his own written introduction states that it is not a legal opinion, and that anybody, when referring to the Good Government Guide, must take into consideration that laws change and whether or not something is in there is necessarily lawful simply because it is there. And he has also been very careful not to issue a legal opinion. There have been memorandums, which my understanding is a legal opinion has to come out under the signature of the city attorney, and has a certain form that it must be in for it to actually be a legal opinion. And they've been very, very careful throughout all of these issues just to have a memo. And bottom line, as we all know, everybody can write a memo, just like we're talking about an OD here, where somebody wrote it with an erroneous statement in it, and anybody can write a memo which has erroneous statements or misconclusions of law or so forth. So I think going back to the full task force will serve another number of purposes.
Thank you. Is there any additional public comment on this matter? Okay. Member Wolf?
If it's agreeable to the maker, I would take member of the public Hart's suggestion to send this also to the Ethics Commission, have it sent to the Ethics Commission, but also with some verbiage that while we appreciate their opinion, their job is to carry out enforcement. I would also suggest, and I think member of the public Hart's had said it good too, that we include in the system-wide announcement quote it from the Good Government Guide, the statement that this is not this is not a legal opinion, and that, you know, laws change and so on. The preamble to the Good Government Guide, that we included in the announcement so that people know that what they're reading, they could read the Good Government Guide as a guide, but what they really need to be reading is the Sunshine Ordinance. I think that might be, you know, more helpful to the public, to the city family, and give them some pause as to whether they're doing something right or wrong, not to stand on the Good Government Guide as the end-all, be-all. Because obviously this is one of those cases where we find in opposite of the Good Government Guide with regards to the them stating that its attachments are okay. You know, and if there's no real legal opinion on it, then what we say goes.
As long as we don't have to use that phrase "city family." There is no such thing as the city family. It's our. The city belongs
government
to everybody, and using it empowers it. Sorry. Well, then what are we? What is the Sunshine Ordinance?
Right. No, I'm using that.
I know.
Or the stepchildren.
Yeah.
The redheaded stuff.
Remember Wolf being a social worker.
Could we leave the motion the way it is and make the recommendation when we discuss it at the task
Why don't we
force?
do that?
Yeah, we
So, okay. Mr. Rustin, would you call the roll?
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, 4 ayes. The motion passes.
It's past time now for general public comment. So at this time, members of the public?
I'm beginning to feel fatter for the simple fact that I'm the only member of the public today.
There's one more.
Oh, there's
behind.
Well, there is. I'm sorry. I didn't mean it that way, but every time public comment comes up, I'm up until recently just the only person. I really do appreciate what I perceive to be a real change in direction for the task force. The good government. The Sunshine Ordinance to me is an extension of the First Amendment to the Constitution, the California Constitution, the Brown Act, and so forth. It is simply something that is there as an addition to and a support of all of those other places. And when I really think about the time I spend in city meetings and watching people during public comment and watching how public records requests are handled, not only my own but others, it really does really push my buttons in the sense that I hear from my mother all the time, lives in Florida, who's very right-wing Republican, about how San Francisco is this liberal nuts and place. And I say to her, I've been a lot of places where government is much more open and much more accessible to people, and it is much less likely to be abused by people in government who feel that they have the right to silence public comment and to do what the Brown Act decision actually talked about, which was to maintain the status quo. And really to make public comment sort of meaningless. One thing I've said to a number of public bodies is that my two primary issues for being there, other than what I might discover when I go, is number one, to ensure public comment is allowed and respected, and number two, to ensure that the people who need public records to make those comments, which are often the very basis of their free speech exercising of those rights, are carried out. And I think that in any case where citizens are discouraged from participating fully, that it is a disservice to the public, but it is also a violation in many cases of the oaths that the members of various commissions take. If I'm a member of a commission, one of the oath I take is to support and defend the Constitution of the United States. And I think if there's anything I should be considering, it's when members of the public come forward that I ensure that they have every right and every opportunity to speak. And if there's a question between, and I hear this comment a lot of times that, well, if I let this person talk, then this is going to happen or that's going to happen. And it's like, well, you could do two things. You can let the person talk and you've lost 3 minutes, or you can not let them talk and you've violated you've disrespected the flag that is hanging in most of the rooms where you're sitting. And I think if the choice is there, it's a pretty simple one to me.
Thank you.
Hi there, Alicia
Hi.
Gamis. You might remember me from the last few meetings. Just just here to give an update of sorts. Since the order of determination in last month's meeting, the department has stated to me, Dr. Bhatia has stated to me that he has identified hundreds of records. However, he hasn't provided them. 2 weeks ago, he sent me a document that had 5 pages in it, and he said it would be forthcoming on a rolling basis. Prior to last month's meeting, he had sent me a couple of documents at about 30 pages, maybe. Subsequent to that, he said there are hundreds. At that point, he sent me a document that had 5 pages in it. The following week, nothing. So far this week, nothing. I had previously in an email and otherwise stated to him that the goal was to try and get sufficient information in order to comment at the last Noise Ordinance Task Force meeting, which happens this Thursday. I believe his conduct is to frustrate the effort to comment effectively at that meeting, which further frustrates the fact that for the last 3 years, there has been zero public comment at any of those meetings. I don't know what the power this task force has, but I would just like to bring this to your attention. I have heard nothing about the Noise Ordinance Task Force mission being extended to provide further opportunity or supervision, public supervision attempts to make that process, that department more transparent, nothing. So right now, the appropriate public comment is being suffocated in its little cradle, and the meeting is on Thursday, and that's it. So there's effectively no opportunity to materially comment on the department's practices in enforcing the noise ordinance that task force then was meant to do. So,
Thank you. Member Johnson?
See a couple things. The Department of Public Health, under Section 2918C of the Police Code, the Department of Public Health, no matter what they say at that meeting on Thursday, they don't have the option of sunsetting their own. It's not up to them. Only the board can extend it, the Board of Supervisors. So they can recommend that they sunset, but the board. So we have a letter that'll go out tomorrow morning, no later than tomorrow morning, that is recommending that the mayor and the Board of Supervisors extend the sunset date. And it doesn't sunset until November of 2011, because it's 3 years from the date of the enactment of the resolution, which is November of 2008. Mm-hmm. So the board can actually require the Department of Public Health not to sunset the Noise Ordinance Task Force. They can make that determination up to November. So even if they make a recommendation that even if the Noise Ordinance Task Force recommends that they sunset, they won't sunset until November. So the board could recommend. So my suggestion to you would be you'll get a copy of the letter, and I would suggest that you petition the supervisors and ask them not to
Allow it to sunset.
Yeah, or to extend the sunset date. And the letter says basically what Member Washburn said at the meeting, the last meeting with the order of determination, where the idea would be to extend it to give the public an opportunity to participate in the recommendations for the noise control. That's what it was for. So depending on what happens on Thursday, maybe they'll decide to extend it. I don't know.
And that is my concern, because they have very effectively withheld information in order to make material comment there. I don't have the information. It's in less than 48 hours. What can you do with that? And so I guess what I would like
You
to
could do an IDR,
What's that?
an immediate disclosure request.
I
But
have
then it's,
been
it's
actually
almost too late now.
Yeah, while sitting in the audience, I've been emailing back and forth, spatting with Dr. Bhatia a bit. He claimed that he didn't know, and I quoted my own email back to him where I very clearly and directly stated that it was for this purpose, and he says that he's going to try and get staff to do something about and provide me with documentation tomorrow. It still frustrates. I mean, there's no way to, even if they were to deliver it now, I'm a human and I have other things to do, and it's still very effectively quashing any material public comment. And so I guess what I would ask is to add a sentence in the letter that says, as of such and such date, the department has identified but not delivered. And Mr. Rustum has been CC'd on these emails, by the way, so it is within all of the conversations are within your reach. By the way, I would just like to follow up and say that. Public efforts for a transparent government are failing. And that is, I appreciate what the other member of the public was saying. It is about I would say further, it's not just about the First Amendment, it's about democracy. It's fundamentally about democracy, and that's what's not happening here. So.
Member Wolf.
Do we know if there's any clarity as to how noise ordinance complaints are going to be handled after the task force is sunsetted? Is it become an issue for building inspection? Is it police department, police commission kind of thing? Is it?
It's in the police code.
It is in the police code right now. The enforcement of the noise ordinance is somewhat distributed. Largely, environmental health seems to have it.
Not talking about.
But the police department does have some. But there are no policies and there are no procedures.
I'm not talking about enforcement. I'm talking about appeals.
Oh, there is no appeal.
Right.
There is no appeal at all in the noise ordinance. It is not. It is unappealable.
But usually, like, if a building inspector goes out and cites a location for this or that violation, there is an appeals process for that under building inspection. If building inspection goes out and finds a code violation, there's an appeals process for that.
And I did pose that to Mr. Rivard during our very first phone conversation, and he very helpfully informed me that there was no appeal and that he was the final word on it.
That's not my point. It's
okay. Currently it is. Currently, I think that's the answer.
Okay. All right. Okay.
Frustrating.
Yeah. Very much so. So we have a situation here where I'm looking at our minutes, and we had we had advised Dr. Bhatia to work with Dr. Gemez to identify.
That's not on the agenda.
Pardon me?
You're discussing something that's not on the agenda.
Oh, sorry.
I hate to say it, but I'm afraid that's what they'll come back. The noise ordinance task force people will come back at us with it because they're not here.
Right. Okay.
Well,
right. Yeah, we can basically just hear you out.
Is it possible to tell me what appropriate next step is? Is that something? What is it that? one does to
You could either make a new complaint about documents related to the minutes. I mean, I think your most
Can-
immediate thing right now is to keep it from sunsetting.
Sure.
And that's the Board of Supervisors. I don't know if you have,
Do you have the ability to reopen it? The prior complaint?
You file a new complaint.
well, I mean, the order of determination is still,
Right, it's still a matter of, that's what I was getting to. I mean, we
can't really, I mean, we can't discuss reopening it because it's not on our agenda tonight. We have to put it on the agenda because the other people have to be noticed for due process.
We could, she could request that it be put on the agenda for the full task force meeting. No, can't do that.
I mean, that's a new complaint and following up with the board is the I think the most doable.
Does this task force have the ability to take note of continuing noncompliance and do something further?
Where did we refer this to?
We referred it back to the back to the full. Okay, we heard.
So I should say, if it is possible for us to do that, we should not talk about it right now, because
Yeah,
anything that
I'm
we
sorry.
talk about right now that leads to some action by the board would be a violation of the Brown Act. So
Yeah, you're right.
if there's anything we can do, according to what you just, similar to what you just said, then we really shouldn't talk about it now, because it could lead to the board or the task force ultimately doing that.
The Sunshine Ordinance Task Force.
Yes. Yeah, sorry. Sunshine Ordinance Task Force.
But it is the case that you can always file a complaint. That's just, kind of rock bottom what you can do.
Can anyone tell me when the deadline is for the next full meeting to file a complaint?
Mr. Rustum?
Through the chair, that deadline has passed.
Okay.
What was that?
The deadline has passed.
The deadline has passed for the next
Right, for it to be heard
in
September.
September.
So it could be heard in October if you file one.
Okay.
Okay.
What else we can do? It's public comment.
Yeah, public comment. So,
Okay.
all right.
Thank you. And I commend you on your apparent efficiency in having worked through other.
Thank you. Mr. Rustin, would you call the next item on the agenda?
Item number 7 is next steps on Ethics Commission proposed policy for handling sunshine-related complaints.
Okay. I have to say that in rereading the minutes and then looking at some notes I had at home about things I was to do, I was to contact the chair of the Ethics Commission to hold a meeting, which I did not do. I've just been very jammed with work and traveling. But I understand that they did not bring this up at at the meeting yesterday. Is that true?
Yeah, they didn't have it. The Ethics Commission didn't have it on their agenda or on the executive director's report.
So which actually is a good thing for us. So we can request a meeting before their next Ethics Commission meeting. So.
Yeah, but we have to actually do it. We have to send it to the commissioners and to the executive director to request a meeting. And I would add I don't know exactly how to put it, but I would add something along the lines of requesting a status update be on their executive director's report or, something along the lines, or maybe we could get a status report on where they're at with it, since in August they said that the staff would make a recommendation to the commission, and then it wasn't on anything the next meeting. So, maybe they're still working on it. I don't know, and I wasn't able to go last night because I was at work, but...
Or they're busy writing us responses.
Yeah. No, I had to work, and it was, I couldn't get there. So, but it's hard to, keep track of it and follow up on it. So we really need to ask them for a meeting.
So, how should we, so in drafting the letter, we should ask them for a meeting within the next 3 weeks? And ask them to propose some times, and then all of you let Chris know, we'll let each other know when we're available, and try to get something scheduled in the next 3 weeks with the members of the commission. Okay. All right, I will draft that letter by tomorrow. Okay. All right. Mr. Rustam, could you read the next item on the agenda? Oh, public comment on this matter. I see no members of the public. Mr. Rustam, would you call the next item?
Next item, Madam Chair, is the administrator's report. I have nothing to add. Only to let you know that all of a sudden I got 5 Ethics Commission's findings, all came in within a period of 2 hours.
Yeah, real fast.
And I think that was the, what had happened was Mr. Grossman on Friday had sent me an IDR asking for all the outstanding.
Oh, yeah, he did.
All the outstanding what?
For all the outstanding Ethics Commission responses. And so I sent him all whatever I had received, whatever I had not. I updated the website and I told him what's what. And with that information, I think he confronted the Ethics Commission last night.
Last night,
yes.
You say that he filed a lawsuit or he filed an IDR?
IDR with me.
Okay.
You're saying he got all the ones that we had, and then took him to you think he probably took him to the Ethics Commission last night and said, where are the rest of them? And then they issued the rest of them today?
Yes.
Oh, I see.
Some of them were old.
Yeah.
Dates back to 2010.
Wow. They're getting nervous.
Wonder if they CC'd the civil grand jury.
Maybe we should.
Maybe we should, right? All right. Is there any public comment on the administrator's report? Seeing none.
Item number 10 is announcements, questions, and future agenda items from committee members.
Also, in reviewing the minutes and noticing what I'd promised to do and had failed to do, from last meeting, Member Wolf suggested that this committee discuss its scope and objectives, and that I suggested that the clerk place it on the next agenda. So if you could place it on the next agenda so we can sort of take stock of what we do here, that would be a good thing.
I have one quick question. I'm not sure about if it's something that compliance and amendments would discuss or the full task force. But did you notice that, I don't know if it's a newer part of the Ethics Commission's website, but they have a chart that lists their action on the complaint or whatever it is. It's got some political election ones and it's got some sunshine ones, and then it has a one-word kind of description. You can click on it. and all of ours say dismissed. And I want the task force, I don't know if it's something that should be here, or the task force, to request that they not say that. Because the reality is they decided not investigated. They're not dismissing it. They're not investigating it. Is that here or the...
I would say that, first of all, if they say that they're not investigating it,
No, they don't say that. They say dismissed.
okay, but they shouldn't be investigating anything.
Right.
They should just be, I'll say it now for probably the 6th or 7th time, just enforce. So, if they are not carrying out their charge under the Sunshine Ordinance, that's problematic. The question then becomes, who do you complain to on that?
Well, I would definitely. I mean, I'm already. I don't know. I guess maybe it's a full task force issue. I don't want to discuss it, but kind of want to break any laws. But
I would say put it on the agenda for this coming meeting, for discussion and possible action. And I think just thinking about it, the only we'd have to appeal to the Ethics Commission directly. I think that would be the first step.
Okay.
Lots of times we know for a fact that what the staff does and what the commission gets to hear or see or feel is like, the splitting of the sea. So
it just seems deceptive to say dismissed. It
It's right.
sounds like they're, but they're really not taking it up. It's the Ethics Commission not taking it up. They're not able to dismiss a sunshine complaint.
let me ask, are we running a tally of what we send to any enforcement agency and whether we've got a response, are getting responses, or if actions have been taken or anything? Are you keeping any kind of tally, Chris?
Through the chair, I don't have a sort of like a database, but whatever we send, whatever we receive back is all on the website.
Oh, okay. It's on the website.
On the website
Okay.
under documents.
Okay, great. So that would be, that would be a helpful to take that and see and match that up to their database and see what's going on, and then just keeping the tracking things, I think, is a good task for all of us. All right, move to adjourn.
Second.
Thanks, everybody.
Rock the